Compulsory licensing. An application for compulsory licensing can be made under 4 provisions of the Patents Act. In other words, there are 4 types of compulsory licensing. The first one is under section 84, this next one is under section 91, you have another kind of compulsory licensing under 92, and the 4th type of compulsory licensing is under 92A. We will tell you what these things are in detail. For an application under section 84, it is necessary to establish a prima facie case. Any person who is interested in having a compulsory license issued on a patent, after the expiration of 3 years from the date of grant, he can make an application under 84. The conditions are 1, and these are the conditions for section 84. 91, 92 and 92A have different conditions. So we are just mentioning the conditions for 84. The conditions are 1, the reasonable requirements of the public are not satisfied. That is condition number A. So if an application has to be made under section 84, the first condition is that requirements of the public are not satisfied. Second, the invention that is subject matter of patent is not available as a reasonably affordable price. So the first requirement is public is not satisfied. They are not getting the invention that is covered by the patent. Second, they are getting it, but it's not at a reasonably affordable price. So the second condition is linked to price. The first condition is linked to the availability itself. Okay, and the third condition is the invention or the patent is not worked in India. So it could be on any of, it's not that they are cumulative, on any of these grounds a compulsory license can be issued. The fact that the patent is not worked in India, the fact that the patent is not available for a reasonably affordable price, and the fact that the reasonable requirements of the public are not satisfied. Now let's look at 84. 84 is what we call a third party initiated license. Okay, and it is initiated by the third party because 84.1 tells us that at any time after the expiration of 3 years from the date of grant of a person, any person interested may make an application. So it has to be initiated by a third party. The third party may be an NGO, the third party may be a competitor in the industry, or third party could be somebody in the market. So they are called third party initiated compulsory licenses. The initiation has to come from a third party. The procedure is that if during an application adjournment is asked for, if time is not enough to work a patent, it can be granted. The controller has the power to grant extension in time if the application is opposed, in the sense that somebody makes an application for the grant of a compulsory license. Obviously the patentee is going to oppose it. The patentee will oppose it by saying that this is not a case that need to be granted a compulsory license. Now the factors that has to be considered before the grant are mentioned in section 84.6, that the nature of the invention, what is the nature of the invention, the ability of the applicant to work the invention to the public advantage, because if he is saying it is not locally worked, then the controller will expect the applicant for the compulsory license to work it, the capacity of the applicant to undertake the risk in providing capital, then as to whether the applicant has made any efforts to obtain a license. These are the conditions. Ability to work, capacity of the applicant, failed in obtaining a license. Now the controller also has the power to pass certain incidental orders. He can grant licenses to customers of the applicant, he can cancel and amend existing licenses, grant licenses for other patents, revise the terms and conditions. So that's with regard to an application under section 84, what we call a third party initiated compulsory license. The second category is licensing of related patents. Patents that are related can be obtained by a compulsory license. Now any person who has the right to work any other invention as a patentee or licensee, this is the requirement. in a licensing of related patents, the person who makes the application for compulsory license should have a related patent. He should already be a patentee, or he should have the right to work an invention as a licensee or as a patentee. And the fact that by working his invention, he may require a license from the other patent. So, if he requires a license, then 91 allows him to seek a license of a related patent. The ground given here is that the first mentioned patent on the ground that he is prevented or hindered without such license from working the other invention effectively or to the best advantage possible, which means I have a license, I have a patent. For me to work my patent, I need your patent, and you are not giving me a license. So I can approach the patent office and say that I cannot work my own invention, and I am prevented or hindered from working my own invention without a license to your invention. Which means if I do something with my invention, it may infringe your right and you may stop me. So I can go to the patent office and ask for a compulsory license on your patent. So this is what in law we call cross licensing. Normally parties will give a cross license. If you require a cross license and if the party is not cooperating, then you could approach a patentee under section 91. The provisions on section 91 are different because the requirement of waiting time is simply not there. In 84, you need to wait for 3 years. That requirement is not there. But the other provisions like procedure for dealing with applications under 84 and 85, the same procedure applies, but the fact that you need not wait for 3 years after the grant, which you would do under section 84, does not apply. Okay, so there are some differences with regard to the way in which 84 operates. You saw that in 84 there is a requirement that you have to wait for 3 years after the grant, and you have to make on any of those 3 grounds: reasonable requirements of public not met, not available at an affordable price, not worked in the territory of India. So those are the only 3 grounds on which you can make a application under 84. But under 91, the fact that you have a patent and you can't work the patent without the license of the other patent, that alone is enough. Okay, and there is no 3-year waiting period. So you can call this as a fast track process. Now, prevented without such license from working the invention efficiently. Conditions: the patentee you should have tried it, but the owner of the patent did not grant you. So you were willing to grant and procure the license of the other invention, and you make a substantial contribution to industrial activities, which means you have some industrial presence, and you are already doing some activity in India, which any manufacturer in India would qualify for. Substantial contribution to establishment or development of commercial or industrial activities within the territory of India. So these are the 2 requirements. One, you should be willing to take the license and grant the license in return, because this section 91 comes with a cross licensing provision. So if you are seeking another person's patent, you should be willing to grant a license of your patent. Okay, so so you should be willing to grant your invention as a license, and you make some substantial contribution to industrial activity. Now, the third type of compulsory license is what we call special compulsory license. Okay, it's called a special compulsory license because the provisions under 84 and 91 don't apply in this case. Now, these licenses are issued in cases of a national emergency or in circumstances of extreme emergency. National emergency, extreme emergency, national emergency, which is something which affects the entire country, like the country is in war or national security is affected. Extreme emergency could be something which is immediate but need not be on a national scale. That's how we understand that. Or in cases of public non-commercial use, the government of India feels that there has to be a public non-commercial use of the invention. Everybody needs it. Say avian flu or some kind of bird flu hits one of the major states in India, and the Indian government wants a patented drug to be available to the public on non-commercial use, free. I mean, it's not being actually sold, but there is a disease and we need medicine, so you could use a special compulsory license. The special compulsory license is issued by the government itself. It is not issued by a third party making a request like 84, or a patent holder of a related patent making a request under 91. Okay. Now 92 simply says that one, if the central government is satisfied that the conditions exist, it may make a declaration so that to that effect by notification in the official gazette. Okay, and when that is done, the controller shall, on application made at any time after the notification, grant applicant a license to a patent on terms he feels fit. So, what are the requirements under 92? The central government first makes a declaration by notification in an official gazette. So, the central government makes a declaration that this is a matter on which a compulsory license can be used. And after the central government makes the declaration in the official gazette, a person makes an application to the controller. Okay, it's the controller who ultimately grants a license, but there is a background. The background being the central government should issue a notification in the declaration in the official gazette. Now, this includes public health crisis notification by the central government is required. The fourth category is what we call compulsory license for export. This largely covers the manufacture and export of pharmaceutical products. Now, this provision can be used when you want to export to a company having insufficient manufacturing capacity. So, this provision cannot be used to export to US or to Europe. It can be used, the Act says that it is a benevolent provision to help another country which does not have the manufacturing capacity. Again, to address public health problems, such countries should allow importation from India. That's another thing, and this should be done by way of an authorization or a compulsory license in that particular country. Now, 92A(1), if you look at 92 capital A(1), the compulsory license shall be available for manufacture and export. So it is export clubbed with manufacture, because we want the thing to be manufactured in India and then exported. A provided compulsory license has been granted in such country, or such country has by notification or otherwise allowed importation. Okay, so they should have. If India has to grant a license, compulsory license for manufacture and export, the condition is the other country should have granted a license, and or the other country should have given or notified or allowed the importation. So two things: it should allow the importation, or it should have granted a compulsory license in that country, because compulsory license will now allow people to import from India. Now, section 85, though it comes under the chapter on compulsory license, it gives the power of revocation of a patent. Now, this is what we call revocation in cases of not working. Any person and the central government can take an action for revocation under section 85. The conditions are: after 2 years after the grant of the compulsory license. This can only be done 2 years after the grant of the compulsory license, which means under 84, for somebody to file an application for compulsory license, he should wait for 3 years. And after 3 years, if the person says that after 3 years of grant, the patent is not being worked, he would get a compulsory license. Now, when such a compulsory license is granted, and after 2 years, it is not being worked, the invention is not being worked, reasonable requirements of the public are not satisfied, and it is not available to the public at an affordable price, same conditions which you saw, then the controller may come to a conclusion that the invention itself can be revoked, the patent can be revoked. Now 85.1 tells us that the compulsory license has been granted after the expiration of 2 years from the date of grant. A person can apply, either a person or the central government can apply to the controller for the order revoking the patent. Okay, on the ground what we mentioned, the 3 grounds that are mentioned here. On these 3 grounds, they can say it is not being worked, hence revoke it. Every application shall contain particulars, such particulars as may be used, the facts upon which the application is based. 3. If the controller is satisfied the requirements have not been satisfied within the territory of India, not available, then he may revoke the patent. Okay. Then every application under section 1 shall ordinarily be decided within 1 year of it being presented to the controller. Now this is the only provision where there is a limit of time for the controller to dispose it. If you see 85.4, it tells the application shall be disposed of within 1 year. Okay. Now this is a provision that has not been used at all for multiple reasons, because this requires, one, the fact that the patentee has not worked this invention for 3 years, and it requires a person, interested person, to make an application under section 84, and after he makes the application for section 80 under section 84, in 2 years he himself does not manufacture it, and after that somebody else has to make, or the central government has to make an application under 85 for revocation. Quite a long drawn process, and it can be frustrated at many points. We have not seen a single revocation under section 85 so far, because it is tied to a grant, and that grant is tied to a compulsory license under 84, and if that doesn't work in 2 years, only then section 85 kicks in. Very, very circuitous, and we have not seen this being worked at all. Now there is also a provision for termination under 94. The provision for termination of a compulsory license that has already been granted. An application can be made to the controller by the patentee or an interested person. License holder also has the right to object such termination. Application shall be made in form 21. Now this pertains to compulsory license granted under 84.